Let me start where we kind of left off after the legislative update. I got around to talking about all of the bills, but the last thing I wanted to do, the last part of what I wanted to do was to talk a little bit about why we were calling it the session of death by 1,000 cuts and how we got there and what it means for next year. Because as I said on that last slide, a number of these are issues that are going to come back. And they were kind of put off by some deft negotiating by some of the legislative teams from primarily the league, but UAC also helped in there, and us planners helped a little bit in there, and we did some good stuff. But the ones that are definitely coming back, this short-term rentals, that's definitely coming back. We've been told that, and we have some deals to work through on that. We made some commitments with regard to this water conservation amendments, and this the local government licensing is probably going to come back in some kind of a form or another. And so we need to talk a little bit about what's happening there and why. So it was death by 1,000 cuts for some of the reasons we had talked about earlier. But what I really think it is, and how many of you ever saw the movie Cool Hand Luke? Right? And I've talked to a couple people that have said, that's my favorite movie. Well, there was a great line in that movie when Paul Newman is the guy who was arrested for the parking violation or whatever it was and keeps getting beat down by this guy at the prison. And the prison guy says at one point when Cool Hand Luke's lying there and out and he's not complying, and the guy says, what we have here is a failure to communicate, right? That's kind of what's happened to us in this last legislative session, and I think why we were getting some of the things that were happening. We have a failure to communicate amongst ourselves as local governments with regard to some of the things that have gone on both legislatively and by the courts over the last few years, and we're not getting the word, or we're not understanding the word, and it's getting us in trouble because we have folks that are out there that are trying to do some things with regard to our land use codes and ordinances, and we're not letting them, or we're doing things and the others are saying, I don't think you guys can do what you're doing, but we haven't gotten the word, or we haven't figured it out, or in some cases, just downright ignoring it. And we got to stop that, or else we're going to be in big trouble legislatively, and I'll show you what I mean. I'm going to go right to another movie, Princess Bride. Y'all remember that, right? And in this case, when he says, I do not think that word means what you think it means, all right? What this relates to is short-term rentals. Short-term rentals became a big issue in this legislative session because here's what happened. Airbnb, many of you are familiar with Airbnb. Hopefully all of you are, and I bet every one of you in your communities has got someplace listed on Airbnb. You just may not know it, or you may not care. But Airbnb is everywhere nowadays and doing a lot. Well, in some communities, they're kind of running into issues about whether the places that they're renting, the homes that they're renting out, are licensed or not, and whether it's legal to do that. And there's some of the questions that come about. So around the country, Airbnb has been taking some different tactics and approaching this. In Utah, they went around to a number of different communities and asked the communities and said, we'd like to do short-term rentals in your community. In some of the communities, Nick, keep me straight on this if I'm getting this right. Nick Jarvis with the league is here with us, and you guys just talked about this last week in your conference. In some communities, they were getting the answer, we don't allow them. And Airbnb said, well, we've looked through your ordinance, and it doesn't say anything about short-term rentals in your ordinance. Or it specifically doesn't say they're prohibited. And in a number of the communities, the response they got was, well, if it's not specifically listed in our ordinance, that means it's not permitted. So therefore, since we don't say you can have short-term rentals, it means you can't have it. Well, that's a problem. And here's the reason why. In 2014, a couple of years ago, there was a court case that was decided. It actually was from a little bit earlier, but the State Court of Appeals made a ruling in 2014 in the case of Brown versus Sandy City, and it was on this very issue of short-term rentals, where you had somebody who was trying to do short-term rentals in Sandy City. Sandy City would not permit it and would not allow them, and the issue went to court. And in the end, what the court, and Sandy City was using that argument of saying if it's not specifically permitted in our ordinance, then it means it's not allowed. And there's a lot of verbiage and everything in court cases, as there usually is, as you can imagine. But the gist of that court ruling was, particularly in the state of Utah, but in a number of places, the rights of the property owners are such that they can do anything with their property that they want to do unless they're specifically excluded from doing it. And so if your ordinance doesn't say that short-term rentals are prohibited, then they're permitted. And so that basically was the decision of that court case. Well, since that came down that way, and you know, in various sessions and meetings, that was all kind of told to people, told to communities that that's what's happened in this case in Sandy City. But a lot of us either didn't hear it or didn't get it and didn't agree with it. And so now we have communities telling a player like Airbnb, you can't do it if it's not specifically permitted. And Airbnb knows full well that there's a court case in the state of Utah that says, oh, yes, you can. So Airbnb went through a number of different approaches, but in essence, they wound up going into the legislature and saying, you know what, because your communities are not playing by the rules, we need to do something legislatively. And what they were proposing to do was a bill that would have prohibited communities from regulating short-term rentals at all. So, I give a lot of credit to Jody Hoffman at the League. She did a lot of work to basically head that off at the pass and try to keep that bill from coming up and basically saying, you know, let us talk to our local government people and let's get this straight without having to do something legislatively. And they were reluctant, but they finally agreed, and that bill did not go through during this session. But there was a promise made that we are going to deal with it during the interim this year. Otherwise, there will be a bill next year in the legislature with regard to short-term rentals. Now, because of what the court ruling said, it said that if it's not specifically prohibited, then it's permitted. The obvious answer to a lot of communities is, well, then we're just going to go change our ordinance and prohibit them. Let me forewarn you from doing that right now, because there was a promise made. The legislature and a number of legislators were ready to act on this bill, which would have prohibited local governments from regulating short-term rentals at all. If we take actions now, if our communities take action now to prohibit short-term rentals, my guess is there's going to be a reaction, because that's kind of like going back on the promise that was made to talk about this in the coming year and see if we can work something out with regard to short-term rentals. And the legislature will take action next year and just flat out prohibit regulation of short-term rentals. So what I'm saying to you, I guess, is this is an issue. It's going to get talked about during this year. And there's going to be some negotiating and some things that are going to happen, and we're probably going to settle somewhere. I'm not exactly sure at this point because we haven't started having those discussions yet, but they're going to come. But in the meantime, please don't go out and precipitously do something that's going to get us all into trouble, which means we're going to have that ability to regulate short-term rentals taken away by the legislature. They were ready to do it this session, and they didn't, by just dint of somebody, you know, Jody, really pushing hard and saying, please don't do this right now, give us a chance to talk about it. So that relates to a little bit of a bigger issue, which is, in general, with our land use codes, we need to be more aware of what's going on out there and acting appropriately, okay? And another good example of that is what happened with conditional uses. We're not going to have a lot of time to talk about this conditional uses part of it, but it's a big issue, and it's getting bigger.
Is that this year?
No. So the conditional uses, Right. This was when I mentioned before about this big war that took place over land use back in 2005, 2006, and you had this big bill, Senate Bill 60, which rewrote the whole Land Use Development and Management Act, the LUDMA, and did a lot of things and made things different in a lot of ways. Well, one of the things it addressed was conditional uses. And part of the issue there was that we had, the state code was written fairly generally with regard to conditional uses, and we had a number of communities, what they were doing is they were basically, whenever you had a use listed in your zoning code as a conditional use, the Planning Commission, who is the administrator for that, was oftentimes, I shouldn't say oftentimes, sometimes in those conditional uses, they were making up the conditions right there in the meeting. You know, they were saying, well, okay, and the best example, and I won't tell you what community it was, but the best example I heard of was they were trying to deal with a conditional use in a residential neighborhood, and they were saying, well, okay, and if you do this, and you gotta do this, and you gotta do this, and then when they said, hey, wait a minute, what about, that's right near the mountain, the deer have gotta have a way to get down and get back and forth. You gotta provide a path for the deer to get through there. And you know, the applicant is going, where is this coming from? Right? And so there was just a lot of stuff that was happening with regard to this, and there was a lot of complaining from the development community about how conditional uses were being handled in the local communities. So, in this Senate Bill 60, back 11 years ago, the provisions were written into the state code that basically said that there's a lot of specific legal language that goes with this, but the gist of it is this. Conditional uses are essentially permitted uses in your zone. The only difference is that with a conditional use, they may at times have some impacts that need some extra mitigation. And you can impose conditions to mitigate those impacts. What you really cannot do is deny it. You really can't deny that conditional use. You can just impose some reasonable conditions that address a specific impact, and what that generally means is you've got to identify, or you really should identify, what the potential impacts are and have some standards about how those impacts should be met, and then you impose conditions to meet those standards. I know I'm sounding really general, but you know, let's say for example you say, well, we'll permit in a residential neighborhood, we'll permit a tavern, say. But it's got to meet these noise standards, right? You can't have this if the noise level's got to be such and such. And so then when they come in and they say, you know, here's what we want to do, and you say, what's the noise level going to be? And they provide all the evidence, and you say, all right, we don't think that's enough. We think as a condition, we want you to provide some extra soundproofing and to do some other things so that we make sure that you meet this noise level standard. And that's an appropriate condition. What you can't do is make up conditions just on the fly or deny it because you just are like, yeah, you know what, we don't think this is really going to fly here, so just deny it. With the standards, with the language, the way it's written in the state code now, that's what really needs to happen. What it almost argues for is that for each conditional use, you need to have a set of specific standards for that use. Now that gets really complicated really quick and can make your ordinance really big and cumbersome. So the advice we're giving people, I'm giving people, is if you don't want a particular use in a zone, don't write it in. Don't even make it conditional. Just don't allow it. If you're going to allow for a conditional use in a particular zone, figure it pretty much like a permitted use. It can go in that zone. You may just need to impose a few standards that they have to meet in order to go in there. But it's going to go in, and that's the thing to do. Now, the problem is, this was done back in 2005. We're finding increasingly that most communities have done nothing about this. That there's still, many ordinances still say, you know, whatever conditions. Or they say you can approve with conditions, or deny. That kind of language is getting us into trouble. And we have people going to the legislature and to the courts and to other places and saying, look, here's what the code says. This is the code that you guys approved, and these communities aren't doing it. It's getting us into trouble, folks. And we need to start complying with what the state code says. So we don't have the time here on conditional uses to go through this. We were just talking about this a little bit during the break here. But in some upcoming conference sessions and other places, we're going to have some specific trainings with regard to conditional uses and how to appropriately implement them in your code, because that's something we really need to get right if we're going to continue to have or maintain some credibility with the legislature when we go and talk to them and say, work with us on land use issues, because we are trying really hard to comply and want to comply. Let's talk about this House Bill 132, which was the bill that was in this last year's session of the legislature and actually was in the session before as well, with regard to the licensing of home occupations, essentially, is what it is. The problem is that this is something that's not prohibited and not something that communities can't do, but the question more is to what extent and how do you do it? And sometimes we get ourselves into trouble by being almost unreasonable. And so the basic idea is here you have people, of course, that have home occupations. They have businesses in their homes. And we write our ordinances frequently to allow for that. And hopefully we have standards for them in the ordinance. But then we also, because they're a business, we license them and charge them a fee. And sometimes we charge them not only a business license fee, but we also charge them an application fee to get a home occupation approved. Okay, that's fine. Many of these home occupations are, as you know, are pretty small operations, don't generate a lot of revenue, don't have a lot of impact. The question really becomes how much of a fee is appropriate, and in some cases, and what really prompted this bill was some people, some folks that had home occupations, and they really thought it was unreasonable what the city was doing in order to permit their home occupation and allow it to operate on a regular, ongoing basis. And so they used the example here of, you have cities, and so you look at some different cities, and one city charges this fee, one charges this, but then some are charging higher fees like this, really, technically, as a way to generate revenue. Because when you look at what the cost is to actually regulate and process, to do whatever you need to do to just assure that the home occupation is legal, it may be they are maybe charging fees that are way beyond that. Well, so that when cities begin to do stuff like that, and counties, I don't mean to just target cities, but counties as well, that do this as well, it begins to affect us all because people feel that's unreasonable, and then they go and first they try maybe talking to their city or county officials, and when they don't get anywhere there, then they go talk to others like state legislators. And then it becomes a target, and that's what happened in this case, that you had some folks that really felt like that what was being charged to allow home occupations to exist, to be permitted and then licensed, was beyond reasonable. And it's hard to look at what was happening in some communities and say, yeah, it's probably true, that it maybe is a little beyond what should be or could be happening. So this particular bill that was proposed really would have created a class of a number of kinds of businesses for which no business license was necessary and no home occupation permit was necessary. And the problem was, when you looked at that list as a local official, you thought, probably a lot of them weren't going to have much impact, but some of them they might have some impact in the neighborhood and the community if they're in a residential neighborhood, and that's what a home occupation is. And so this was kind of like, again, the process of killing a mosquito with a hammer, it goes way overboard. And so there was a lot of discussion and negotiation that went on. Again, the League, Jody Hoffman and others, and Cameron Deal took a lot of time and effort to work with the sponsor of this bill to water it down, get it to where it would be something that would be more reasonable and preserve some local option. But the bottom line was, there were going to be some restrictions on the types of home occupations that that a local government could require to be licensed and permitted, and the fees that could be charged for those. And then there were some issues there that cropped up again, where after that was negotiated, we had some cities on their own that went to the legislator and to others and tried to renegotiate or change it, and which really hurt our credibility as local governments. And so it became kind of a Donnybrook. The bill didn't pass this session just because I think of a lot of the machinations that were going on. But without a doubt, I would say this bill is going to come back in 2017. The bottom line for all of this is, again, what it goes to is that we're doing this to ourselves by the way we act and by the way we don't act appropriately. And so we, as those who are kind of the staff people, the professional people to help guide you, we need to do a better job, I think, of getting the word out to you all, and then you all need to do a better job of taking appropriate action in your own local ordinances, so that we can demonstrate back to folks who may have some issue with this that we are doing things, that we're responding to these bills that are passed and the new laws that are put in place and the court cases that occur. Otherwise, I think we're going to be in trouble. Now, for this next upcoming year, the Land Use Task Force, which I talked about earlier, and it's sponsored by the League. The League has been really kind of the home for the task force, but counties and others are all associated and work with that. These are the issues that we're going to be talking about this year. We've got some issues about administrative and legislative, about standards of review. That gets pretty arcane, and with the few minutes that we have, I might just talk about that a little bit quickly to distinguish the role for you. But impact fees and all fees in general, short-term rentals for sure, conditional use permits for sure. The subdivision section of the Land Use Act, or the Land Use section of the state code, it has not been modified in a number of years. And there are provisions in there that are pretty old and outdated, and that needs to be modified. So I think we're going to see some changes coming there. And then this issue of water conservation, which we had a bill that would have prohibited the use of lawns in some landscaping requirements. It all had to do with water conservation. In the end, the sponsor didn't move forward with the bill, again, because of the promise to talk about water conservation with the local communities and ways to do and maybe even require water efficient landscaping and doing some other things that would promote water conservation. So these are some of the issues that are coming up. Now, I say this again in all seriousness because we need to take some action. We need to understand what's going on out there, and we need to take some action on our local level. Otherwise, we might face a situation kind of like this, which is, if you can't read the caption, what it says is this guy who's selling porta potties out there in his front yard, and the neighbor's not real happy about it, and the guy says, I don't care what the city said, the state said I could do it. And we might find ourselves in that situation, that we lose local control, that the state may begin to dictate some of the things we can and can't do with regard to land use.